Since 1992, the Center for Continuing Education, CCE, has presented seminars featuring the best in topics and talent. Our programs are available in online, DVD, and CD formats. CCE can also customize seminars for your law firm or corporate law department needs. The Center for Continuing Education is a State Bar of California approved MCLE provider.
Albert Barsocchini, a regular speaker for the Center for Continuing Education, is a recognized legal expert in e-discovery, international data privacy, and corporate investigations. He was Director of Professional Services at Guidance Software, where he directed all aspects of professional services computer forensic investigations, both criminal and civil, internal investigation, fraud and policy, auditing and compliance, incidents response, e-record audits, and customer data audits, and e-discovery. He was Assistant General Counsel at Guidance Software from 2005 through 2011, where he was an expert on all aspects of corporate e-discovery, data privacy, and internal investigations. Albert served as chair of the California State Bar's Law Practice Management and Technology section in 2000. He is a founding member of the California State Bar Cyberspace Law Committee and currently serves as a special master for the State Bar of California in the search and seizure of legally privileged and confidential matters. He received his JD from the McGeorge School in Sacramento, California. Albert may be contacted at barsocchini@gmail.com.
Hello, my name is Albert Barsocchini, and I'm corporate counsel. And today, I'm going to talk about internal investigations, a look at proactive and reactive responses using technology and process. Internal investigations is something that becoming more important to us these days in the world of corporate governance. Because of all the SOX investigations, because of HIPAA, because of all these regulatory compliance requirements, having a good investigative team is important. I'm also noticing a trend for this investigative team to be under the General Counsel Office, which makes a lot of sense since a lot of times this requires a lot of legal oversight in order to do it properly. Normally, an internal investigation is launched by a corporation to understand and diagnose problems within the corporation. Frequently used to help a corporation avoid or limit possible criminal or civil liability exposure and correct significant problems. It's fact-driven, and the old adage that sometimes the best defense is a good offense. Having a strong investigation team is critical in order to protect your corporation from negative public relations issues, from generating lawsuits, and from just knowing that you have good ethical standards to abide by at your corporation. There's a lot of risks if you do a flawed investigations, and that's why it's important to understand the principles of a strong, proactive corporate investigations. Allegations of obstructions of justice can occur if not done correctly. Damage to the corporation's reputation, damage to employee morale, if not done correctly, in the sense that if a employee within the corporation knows that there is an internal investigation being conducted, that could affect morale within the corporation and also could affect the fact-finding mission itself. And also the creation of negative evidence that may be used in future criminal or civil proceedings if not done correctly. And finally, destruction of evidence. It's so important in the days of digital evidence and also paper evidence that it be conducted in such a way that we can preserve it. As you know, laptops and file servers have information on it that can be easily destroyed, and if that's the case, then you could end up with a situation of spoliation of evidence. The first question that you should ask anytime that you're thinking of doing an internal investigation is it appropriate? And in this case, there are a host of factors that you need to look at. Whether the company was a victim or the perpetrator of the alleged wrongdoing. If the company was a victim of the wrongdoing, is it likely to reoccur? And will the company likely recover much, if anything, in pursuing the wrongdoers? What you're trying to determine is create a balance between doing too many overzealous investigations and really maybe directing this to a HR as an issue that they should take care of instead of cranking up the forces that would do an internal investigation. Other issues include whether the alleged wrongdoing, if true, is placing any third party at risk, whether the allegations are susceptible to verification, and the cost and effort of the investigation as compared with any results it may yield. So very important to look at the checklist, determine if the investigation is appropriate, and if so, then to execute it correctly. A good reality check is a quote that I've seen from Don Rumsfeld when he was Secretary of Defense. You're probably familiar with the saying, there are known knowns, there are things we know that we know, there are known unknowns, that is to say, there are things that we know we don't know, but there are also unknowns unknowns. That is, there are things we don't know we don't know. What is critical in internal investigation is determining the unknown unknowns. In other words, things out there that we don't know exist, but that could come to hurt a corporation. Many in corporate governance believe that going after unknowns is difficult, which it is, and also can be dangerous. My philosophy is that it's important for a corporation to demonstrate strong ethics, to be proactive, and to always be on the lookout for issues that it may not know is there, but is something that any corporation in its position should be looking for. Another adage to remember is to always know yourself. Sun Tzu, who was a Chinese philosopher, said that if you know your opponent's strengths and limitations and know your own strengths and limitations, you can win 100 battles without a single loss. However, if you know neither yourself nor your opponent, you will always endanger yourself in the mission. A classic example is not having a good, strong team in place to be able to go after e-forensic or digital investigations. Technology, as we all know, is going at lightning speeds. And more people out there are very sophisticated in using technology in regard to hacking into networks, or for that matter, trying to go after intellectual property. Therefore, it's very important that your corporate investigation team be at the cutting edge of using the latest technology and have the latest in training. A classic recent example of this is WikiLeaks. After WikiLeaks had done a number of disclosures of corporate information, a company, which I will not mention, was hired by certain individuals to go hack into WikiLeaks. And this company was well respected for its forensic capabilities and its technology. It was a leader in cybersecurity. They were successful in hacking into WikiLeaks. However, another organization friendly to WikiLeaks called Anonymous decided to go after that company and hack into it. And they were able to do it very easily, very quickly, and basically almost took down the company. That is a classic example where the company that was doing the initial hack should have been on its guard, knowing that they were dealing with people out there that in some respects were smarter than they were. And it's always very difficult to look at these unknowns, but it's something that we should all be aware of. Another issue that you need to be concerned with in regard to corporate investigations is privacy. Here in the United States, there is no uniform privacy law that's in place. It's really a collection of state rules that are governing and also some federal rules. We are seeing some legislation to try to make it more standardized on a federal level, but at this time, you must navigate state and federal laws. Some of the particular legislation here in the United States that you need to be aware of is such things as the Video Protection Act of 1988, the Cable Television Consumer Protection and Competition Act of 1992, the Electronic Communication Act, the Electronic Stored Communication Act, Fair Credit Reporting, it goes on and on. Having a good understanding of all these privacy laws is critical when you are doing any sort of internal investigation. Most of the large corporations out there today have a privacy officer that oversees corporate privacy issues and makes sure that they are in compliance with state and federal laws. Also, if you're an international company, you have to be aware of data privacy laws in other countries that are a lot more stringent than here in the United States. For example, in Europe, such countries as Germany and France have some of the strongest privacy laws in the entire world compared to the United States. So if a company in the United States was going to search information from employees in a branch office in Germany, they would have to research and be completely aware of all the privacy rules and regulations in effect in that country. As it could be as simple as going after an address or even a phone number of a particular person within an organization that may be located in Germany that could trigger said adverse consequences and violate laws in those particular regions. So being in contact with the data authorities in those areas and having local counsel to guide you through it is critical when you are going to do an investigation that may reach into other countries. So the EU private data privacy laws is one other area that you need to be aware of. And again, there's other countries that are starting to develop their own privacy laws in Australia, Japan, and also down in South America. The next question is investigate what? So you've decided that there is a major issue that does require some sort of corporate investigation. What do you do?